All right, we're going to go on the record on cause number. Can you announce the cause number for me for this case, please?
Yes, Your Honor, this is cause DC 21-00902.
Okay, if counsel can make their appearances.
Yes, good morning, Your Honor. My name is Harrison Oldham. I'm here today representing Penalt Projects, Inc. And for the record, we also have Mr. Steve Regan on the in the call. He is here in his capacity as Penalt's corporate representative, not in any personal capacity.
Okay.
And Your Honor, this is Will Duncan of the law firm Rigby Slack here on behalf of third-party plaintiff Nazareth Dallas LLC.
All right, let's proceed on the special appearance.
Absolutely, Your Honor. And before we begin, would you like a brief background about why we're here? Because it's been a little bit of a strange order of effects here.
I mean, I've read all the briefing, but if there's something else you want to add, you're perfectly welcome to.
No, that's fine, Your Honor. If you've read the briefing, that's fine with me. So I'll just jump right into it. So Penalt Projects, Inc. has, of course, filed this special appearance here today, and we believe it should be granted for two reasons. Essentially, first, the court lacks general or subject jurisdiction in this matter, and there's an arbitration agreement that binds Nusrat's claims against Penalt and or Mr. Regan. And so I'll address jurisdiction first and then the arbitration agreements. So first, in this situation, there's no general jurisdiction over Penalt Projects. Courts have stated over the years that other than a corporation's place of incorporation or principal place of business, a court can only exercise all-purpose jurisdiction in exceptional cases where corporations' contact with a state are so substantial and of such a nature as to render them at home in the state. Here, in Penalt's special appearance, we included an affidavit from Mr. Regan, who is a director of Penalt since 2017, and he outlines the absolute dearth, the lack of contact Penalt has with the state of Texas. Just to highlight a few of those, Penalt is incorporated under the laws of the state of Wyoming. It's headquartered in Los Angeles, California. It does not have any officers, directors, employees, leases, anything in the state of Texas. It does not produce or market in the state of Texas. It doesn't have a bank account in the state. It doesn't have a phone number or a fax number or anything connecting it to the state of Texas. So in our opinion, there's absolutely no argument that the court has general jurisdiction over Penalt because it's done nothing to prove that the state of Texas is its home. It resides in California and does not come to Texas. So without going further into general jurisdiction, we'll address specific jurisdiction briefly. There, of course, the analysis is whether a defendant has established minimum contacts with the state of Texas. And it, of course, has to happen in the comport with traditional notion of fair play and substantial justice. The question when reviewing minimum contacts is whether a defendant has purposely availed itself of the privilege of conducting activities within a state. Here, Penalt has not purposely availed itself of anything within the state of Texas. As I just mentioned a moment ago, Penalt Projects, Inc. has done essentially nothing in the state of Texas. Any claims that Mr. Regan acted as a director on his behalf in the petitions filed by Nusrat were in his actions as an employee of Nusrat. Nothing connects his actions here as a director of Penalt Projects when he was doing anything. There are no claims that any of his actions were taken in that capacity. Instead, they were all in his personal capacity as an employee of Nusrat. Of course, Mr. Regan's special appearance has already been granted in this matter, so those claims are irrelevant at this point. That is, of course, for clarity, being appealed right now, but as we stand right now, special appearance has been granted. So our opinion is that Penalt Projects has done nothing to purposely avail itself of the state of Texas or the protections offered thereby, so the court cannot have special jurisdiction. In any case, this matter is subject to an arbitration agreement with a forum clause that binds Nusrat's claims against Mr. Regan and or Penalt Projects because of the intertwined nature.
Where is the arbitration to be held?
The state of Florida.
Okay.
It has a forum selection clause and clarifies that the arbitration will be subject to the Federal Arbitration Act. And the court has several copies of the arbitration agreement that have been previously submitted. I also included language from that arbitration agreement in the supplemental brief I filed earlier this week. But as you can see from that language, it is designated to be as broad as legally permissible. And it broadly extends to any claims between Newsret Miami LLC, its parents, subsidiaries, affiliates, anything. It's meant to be as broad as legally possible. Now, of course, Mr. Regan entered that arbitration agreement personally, in his own personal affairs, and he entered that with an affiliate of Newsret Dallas. However, our belief is that the claims between Pinault and Mr. Regan are so intertwined that it would be illogical to try to separate those claims at this point. By way of example, if Newsret wanted to pursue a claim against Mr. Regan and Pinault, like it's doing here, it would be forced to arbitrate its conspiracy claim against Mr. Regan, but then could seek out a court's jurisdiction to bring its claim against Pinault. That is just, in our opinion, illogical. And courts have found in multiple situations where cases are so intertwined that even non-signatories to an arbitration agreement can be compelled to arbitrate under that agreement. And in the supplemental brief, I pointed out 3 of those factors that would apply here today. And they are, of course, agency. Here, Newsret's arguing that Mr. Regan acted as an agent on behalf of Pinault when it was taking its actions in Dallas, Texas. The second is alter ego. In its second amended petition and counterclaim, Newsret stated and argued that Mr. Regan is Pinault is the alter ego of Mr. Regan. And finally, it's just the alternative estoppel theory, where claims are so intertwined that they must be compelled and compiled into a single matter. And that we believe that applies here today. Just because these claims are so intertwined, it would be impossible to separate them out. Even looking at the petitions from Newsret, Mr. Regan and Pinault are consistently referred to as the co-conspirators or the co-defendants, etc. So for those 2 reasons, we believe the special appearance for Pinault should be granted. Thank you.
Response?
Yes, Your Honor. So I think my client's responses to all of that have been in our prior briefing. And as you know, the parties briefed this issue 5 or 6 months ago, and then Your Honor issued an order overruling the special appearance. But to the extent we want to address any of those specific arguments, I'm happy to do that.
I guess my main thought is, okay, let me make sure I kind of following this. So he's arguing this arbitration clause applies, but your client is not a signatory to the arbitration clause, correct?
Correct.
And correct as well. Yes. Neither of our clients are signatories to the arbitration clause.
Okay.
May I respond to that point, Your Honor?
And you're arguing that, I guess my thought is, okay, well, I guess as to that issue, I think we need to make a determination I think we're jumping the gun here. If they're subject to the arbitration clause, then this case probably should be dismissed and go to Florida. If they're not subject to the arbitration clause, then we need to deal with just general special appearance, minimum contacts, analysis. And so my thought is that really probably that issue should be resolved through a motion to compel arbitration, not through a special appearance. But go ahead. What were you going to say?
I was just going to say, Your Honor, the arbitration agreement is Newsret Miami and extends to all of its parents, subsidiaries, and affiliates. It extends to claims covered by Newsret Miami and its parents, subsidiaries, affiliates, any other entity. And of course, Newsret Dallas and Newsret Miami are affiliates. So even though Newsret Dallas is not a signatory, it extends to claims covered by and including those parties.
So Your Honor, I'm going to direct the court to the specific language, and that representation actually isn't correct, because the agreement certainly applies to claims and mentions affiliates, subsidiaries, and entities. But if you look at the language, it's actually one way, and the reason is because the arbitration clause doesn't purport to broadly bind non-signatories as to the claims that they can assert. And so it says, This agreement applies to any claims or disputes that the company, Nuzrat Miami LLC here in the agreement, may have against you, Mr. Reagan, or that Mr. Reagan may have against any of the following. And that is where the parent subsidiary affiliates, that's where that clause is. That's not two ways. Here it is an affiliate, certainly, asserting a claim, but if the entire second part of that paragraph were read to apply the way that that Penalt is arguing today, a employee of Nuzrat Dallas who had an intentional tort committed against them would not be able to seek relief in a Dallas court related to that intentional tort because according to this argument, that individual would be covered by an arbitration clause signed with a different entity, Nuzrat Miami LLC, by Mr. Reagan at a different time. And it's our position that the express text does not cover the claims here, if we even get to that. But to touch on the point that you mentioned, Your Honor, we also agreed that the special appearance is about minimum contacts. It's constitutional. All of these cases cited by Penalt are about whether arbitration can be compelled or a non-signatory can show up. But the Texas Supreme Court and Texas courts have been clear that those two issues are separate. And even assuming an arbitration clause covered this, that would not necessarily negate meaningful, purposeful contacts in the state of Texas for the purpose of the constitutional question. And so for both those reasons, we really do not believe this arbitration agreement provides any basis for sustaining Penalt Project's special appearance here.
Why don't you argue the minimum contacts?
Yes, Your Honor. So of course, a moment ago, they said that they're just in a passing capacity and they haven't directed contact or purposely availed themselves to the state of Texas. But the Second Amendment petition and the materials attached lay out these contacts. And if Penalt doesn't want the court to accept my client's word for it, the letter that is attached to the Second Amendment petition literally, and this is from Benj, Texas. This is from the plaintiff in this case, who initiated the action. But Benj, Texas, the general contractor, wrote a letter to my client explaining the way that money had allegedly been taken from project-related funds. And in the letter, it says, and this is not Nuzrat's claim. This is Benj, Texas. It says, once Benj was paid from Nuzrat, he, Mr. Reagan, then had Benj wire the money to his Penalt bank account for his weekly management expenses. The letter goes on to say, Benj was also directed to have all communications via Mr. Reagan's Penalt Inc. email address, unless he specifically told Benj to email him on his Nuzrat email. Penalt here, it didn't just avail itself. It was it is the conduit for how the money reached Mr. Reagan. And this is just from that letter. That letter goes on to attach a record of 19 different payments, I believe, if I counted correctly, that Benj, Texas was directed to pay to the Penalt bank account beginning in September 2019, going to August 2020. There are 19 different payments totaling $182,000, more than that. And this is project-related funds related to the Dallas construction project, for which Penalt Consulting or Penalt Projects was being directed by the general contractor to receive money. And that's not one contact. That is numerous contacts, and that's directly at the heart of the claims in this case. And that's just the contacts described in this one letter. Additionally, there's affidavit in place with the Second Amendment petition that states that Mr. Reagan used his Penalt account for many of the expenses related to the construction project in Dallas, and then sought out reimbursements from third-party plaintiff, my clients, for those amounts. Penalt was the conduit through which the funds that essentially the fraud in this case that has been alleged, it was the conduit through which Mr. Reagan received the funds. And so, I think the record is more than clear that there were many contacts in Texas related to this construction project, and all of these are at the heart of the claims asserted by my client in this case.
May I respond, Your Honor?
You may.
Thank you. So first, I'd just like to point out to the court that the letter we just spoke about extensively is not an affidavit. That is not authorized or notarized or validated. It is just a letter that was provided at some point in the past. It had no connection or purpose of being involved in this hearing today. Second, it sounds like all of those allegations should be between NewsRed and Binge. There's nothing connecting anything Mr. Regan did to the actions Binge took besides these allegations. And so what I'm trying to say is, even though Mr. Duncan claimed that Mr. Regan directed the payments to be sent to Pinault, we have no idea if that was in his personal capacity or as a director of Pinault Project. That was not declared. And then Pinault, the bank account, if it even did receive these funds, would have been in the state of California. There is nothing to connect it or purposely avail it of the laws and the protections of the state of Texas. So essentially, what Mr. Duncan is trying to collect special jurisdiction is over a bank account in the state of California. We have nothing showing or arguing that Mr. Regan acted as Pinault Project's director, connecting him to the state of Texas, just that Mr. Regan and Binge at some point allegedly came up with this scheme and sent the money to a bank account in California. That is not enough to establish minimum context. That is not just and fair in light of the constitutional protections offered for a foreign corporation. And finally, I'd just like to briefly circle back to the arbitration agreement, if you'd like to hear any more on that front.
I think I've said what I'm going to say on that, which is I think that there needs to be a motion to compel arbitration, and we can make a determination of whether or not. I'm going to go ahead and just tell you what I'm going to do. I'm going to deny the special appearance, but I want to make it clear in the order that this is without prejudice to your client filing a motion to compel arbitration. I'm not ruling on that issue because I think there needs to be a full briefing on the issue of whether or not an arbitration should be compelled. If arbitration should be compelled and should be in Florida, then I would probably dismiss whatever claims are subject to whatever claims, at least the claims subject to arbitration should be dismissed so that a Florida court could enforce the arbitration. But I'm not making a ruling on whether an arbitration is appropriate at this point or not. So go ahead and prepare an order on that. So Mr. Duncan, can you prepare an order to that effect?
Of course, Your Honor. And you said you'd like the just so I get it right, the special appearance would be overruled, but doing so would be without prejudice to any party filing a motion to compel arbitration.
Correct.
Okay. We can prepare that and have it filed.
So let me talk to y'all, and then make sure when you do that it includes today's date at the beginning. So where it says instead of on this date, that a hearing was held on October 1st, 2021, and then make sure you share the form of the order with opposing counsel so that they can sign off on it, and then email it to my court coordinator and e-file it as well.
Okay.